5-000876FY, people of the state of Michigan versus Tamala Peterson. Appearances for the record, please.
Thank you. Good afternoon, Your Honor. It's Assistant Attorney General Chris Kessler for the people.
Good afternoon, Your Honor. Gerald Gleason on behalf of Ms. Peterson, who is standing in the jury box.
Thank you. Ms. Peterson, state your full name for the record. Thank you. This is an arraignment on the information. How are we proceeding?
Your Honor, I'll acknowledge receipt of the complaint. We have its formal reading, and she will stand mute to the charges.
All right. I'm indicating a waiver of the formal reading of the complaint. A plea of mute will enter to the charged offenses. As these are felony offenses, you do have the right to a probable cause conference within 14 days. That is scheduled for March 19th, 2025 at 2:30 before Judge McGinnis. You also have the right to a preliminary examination. That is a hearing in which the prosecutor has to establish by probable cause that a crime was committed and probable cause that you committed it, and that will occur on March 26, 2025 at 9 a.m. You have retained counsel had you been unable to do so and declared indigent or unable to hire an attorney. One would have been appointed for you, as you do have the right to be represented. You also have the right to remain silent. Anything you say orally or in writing can be used against you in court. Do you understand? All right. So I've entered the plea of not guilty. The next two court dates have been established. The next issue that needs to be addressed is bond. I will hear first from pretrial services, and then I will speak with you two.
Yes, Your Honor.
Brenda Rogers, pretrial services. I did not interview the defendant. She did decline requesting her attorney. Therefore, no references were contacted and limited background information was obtained. Records show she's 58 years old, have an address in Brighton, Michigan. Information regarding to employment history, use of alcohol or drugs, or any physical or mental health conditions is unknown. The defendant has no prior criminal history on record. She has no outstanding warrants, no pending matters or holds. And given that there is great concerns for the allegations in the presumption of innocence, the defendant does appear to have a stable residence in Brighton. She does appear to be gainfully employed and has no prior criminal history or history of failing to appear. Therefore, it is respectfully recommended that she be released on personal bond. And it is respectfully recommended the following conditions: pretrial services, no possession of a firearm or dangerous weapon, no contact with the co-defendants in this matter, not to return to any Oxford Center, and that she must surrender her passport to the court within 24 hours of release.
Thank you. Counsel?
Thank you, Your Honor. I think obviously it goes without saying the seriousness and quite frankly the tragic nature of these offenses, go without saying. What I would ask the court to take into consideration is, first, when we talk about bond, one of the conditions the court is to consider is protection of the public. Now, this isn't your typical murder charge in the sense that there weren't specific acts of violence perpetrated by this defendant, but the people's concern regarding the protection of the public, Judge, is this defendant owns and operates another location where this hyperbaric oxygen treatment is taking place. And the people believe that the continuing operation of that business poses a serious threat to the public. It is only by the grace of whoever that this hasn't already happened before. And so the people would ask this court to impose a bond condition that this defendant not have any conduct supervising, overseeing anything related to the business of hyperbaric oxygen treatment, because it's the people's position that the defendant, in her lack of care, is responsible for what happened to the victim in this case, and allowing her to continue to run those businesses the way she has been for years only puts multiple other potential victims in harm's way. I do agree with pretrial services, Judge. Obviously, because this defendant has no prior record, there is no history of failing to appear. But with this defendant, much more than any other, Judge, the people are concerned that she is a flight risk. What I will tell you, Judge, is that as part of our investigation, the people discovered that recently the defendant applied for and got a visa to China, which is still active at this time. She also recently purchased an amount of uncirculated Iraqi currency, which is very concerning to the people, especially considering the defendant has ties to people out of the state and out of the country. I would also point out, Judge, that days after the explosion, the defendant admitted to wiping her laptop. She lied to investigators to prevent access to video of the explosion in this case. And a previous investigation reveals that this defendant has told other IT tech in her business to wipe devices to essentially destroy evidence involved in other investigations. Judge, I would note that there are witnesses in this case who I and other investigators have personally spoken to that indicate that this defendant has bullied, threatened, harassed, humiliated, and filed lawsuits against people who, for lack of a better phrase, stand in the way of whatever it is she wants to do. Judge, this defendant also has access to a considerable amount of cash. The business that the defendant ran, the treatments that she was providing were not covered by insurance. And what that means, Judge, is all of the clients of this business had to pay in cash, I mean cash or check. And this is a significant amount of money that this defendant has access to. One of the number of LLCs that her name is attached to boasts about raising hundreds of thousands of dollars in pursuit of, I quite frankly am not sure what. But my concern, Judge, is that this defendant has access, as I said, to a considerable sum of money. She is part owner or linked to a number of different corporations. Quite frankly, Judge, her husband is a forensic accountant, which means they have the means to move and conceal some of this money. And Judge, if I can land this plane, I bring all this up because what is clear in our investigation is that this defendant not only has the means and the ability to leave the state and to leave this country, but she has shown time after time that she has no problem attempting to impede the investigation into her. And quite frankly, Judge, there is no better way to stop an investigation into Tamala Peterson than by her not being here. So that's something that the people would strongly ask this court to consider in setting bond conditions in this case. I also agree that if the court is inclined to allow the defendant to be released, again, passport needs to be surrendered immediately. The defendant cannot leave the state without express permission of the court, and obviously any other condition the court sees fit.
Right, would you like to say anything as it relates to dangerousness that she poses to the public as a result of the investigation?
Well, Judge, again, I think, again, this is because this is a gross negligence kinds of case. It's not that it's the nature of the business that the defendant continues to run to this day. That is the threat that the people are concerned about first and foremost. So the people want this defendant to have no ability to conduct any business or certainly conduct any oversight as it relates to the other Oxford Center location in Brighton. So yes, the people are concerned that she does pose a continuing threat by the nature of the work that she does and the manner in which she does it, I should say.
Right, and in the swear to, I don't know if Detective Trigger, are you going to speak today?
The prosecution.
Okay, in the swear to, I did take some notes from Detective Trigger's swear to, and in that I learned information such as the actual hyperbaric chamber that this young boy died in was past 20,000 cycles a few years ago. Would you like to speak to that?
Judge, I don't want to get too much into the facts of the case. Obviously, I think the appropriate time for a lot of that to come out is at the exam. But yes, our investigation has led us to the conclusion that one of the co-defendants in this case was actively tampering with this particular hyperbaric chamber, and all of the evidence leads us to the conclusion that it was done with the permission and perhaps at the order of this defendant.
And what, if anything, would you like to say as it relates to, I did also take notes regarding lack of safety protocols, including grounding wires.
Yeah, Judge, I think it goes, I shouldn't say it goes without saying, but you know, Judge, the people's position is that this was a very easily preventable situation had the defendant, and again, this defendant is the owner and the boss, for lack of a better word, of these facilities. This could have been prevented so easily if they only would have followed the manufacturer's guidelines, if they would have followed what is considered basic safety precautions. That, in and of itself, gives the people concern. But again, as the court already noted, not only were they not taking precautions, they were affirmatively making things more dangerous by altering the equipment so as it would look as though it was newer than it was. And in fact, one of the things that the people turned up in their investigation is that in the most recent, evaluation of this particular chamber, the number of cycles was less than had been previously recorded. So obviously, Judge, there's, it's very clear what's going on here. And as I said, the people have spoken to a number of witnesses who can and will testify to that fact.
All right, thank you. Mr. Gleason?
Yeah, I'd like to return to the court rule because there are certain factors there, and I think pretrial services started there, and that's where I think we should stay. I appreciate Mr. Kessel's argument, but I want to focus the court there. First of all, with these proffer about threatening people or wiping disks, there's no obstruction of justice charged here. There's no, and if that had occurred, we'd see a count for obstruction of justice. We don't have it. So I think that discounts the argument that's being made there. And certainly a no contact provision will certainly protect any issues there. So no obstruction. I'm going to say that that's something that we'll see in court. It's not here. With respect to the passport, I have it here for the court. And with respect to applying for a visa to China, it's in the passport. It's dated August of 2024. The purpose of the visa, Ms. Peterson's son got married in China. He's married to a person who emigrated from China, and there were relatives there. That was the purpose of the trip. This was not done recently. It was not done after the incident in question. So that, again, and that's right here. The court can look at it if you want to. It's right on there. With respect to the court rules, I did hear and I agree with pretrial services. She has no prior criminal record. She has no record of flight. She's always appeared. Now, and I want to be clear about this. 2 weeks ago, I told the Detroit Police Department, if charges come, we'll appear voluntarily. No need to go arrest her. We'll present her to the court. We'll present her to the police department. Apparently, that wasn't good enough for the Detroit Police Department, and I respect the detectives. But all they had to do was call me, and we'd be standing here voluntarily. Instead, we're in a box being recorded by the media. And I take issue with that, and I've raised that with the Attorney General's office already. We would have appeared voluntarily, just like I voluntarily brought the passport today. Likewise, if there was flight here, I don't know if the court signed the warrant or another magistrate, but it was signed on March 4th. They waited to the 7th to arrest her. If there was a flight issue here, they would have gotten her the same day. Likewise, Your Honor, with respect to the rule, there's no history of substance abuse, no history of mental health issues. And while the crime of second-degree murder is a serious offense, it carries a number of different mental states. And as the Attorney General stated, there was no violent act here. This isn't the type of second-degree murder that involves a shooting or strangulation or other type of violent act. And likewise, there are 3 different states of mind for second-degree murder: the intent to kill, the intent to do great bodily harm, and knowingly creating a high risk of great bodily harm, knowing that death would result. And I don't think you did the swear to, I wasn't here, but I don't think an allegation is made that she intended to kill anybody or intended to do great bodily harm. And with respect to that third mental state, the court should be aware that both of her parents utilized these hyperbaric chambers regularly. And I think that tends to discount the idea that she was somehow operating these with reckless abandon when putting her own family members in that. That's for another day. I recognize that's a preliminary examination issue. It's been raised today. I'm simply responding to it. Your Honor, with respect to what we have to do to assure the protection of the public, this is not a woman who's going to go out and do further violence. Those hyperbaric chambers, obviously, in Troy, that facility has been closed. The ones in Brighton have not been utilized since this happened. They are going to continue not to be utilized. And I, on her behalf, and I can state to you, if you order it, they will continue not to be used. They are not in use and will not be in use going forward. So the protection of the public, as outlined by the Attorney General, has already been solved, has already been prepared. Now, if the court wishes to have some amount of cash to have her show up, I am not hearing a number from the Attorney General. I am hearing a personal bond from pretrial services. And I recognize what the facts in this case involve. It's a tragic situation. A child has died. There are parents in this courtroom. I'm a parent. I understand that. But in this particular case, this woman does not present a risk of flight, And under the circumstances that we've established at the Brighton facility, there's no risk of danger either. If the court has questions, I'm willing to answer them. But certainly, a high bond is not necessary to meet the goals of the court rule here.
Thank you. Next. The purpose of bond is not to punish, it's to ensure the protection of the public and your reappearance in court. This is a very serious case. It involves the death of a young child. It involves the death of a young child in a horrific way. And I'm not going to use the term tragic because I think a lot of what we're looking at was disregard of safety protocols that created the risk of this happening. And that's exactly why we're here today. Had a grounding line been employed, had the tally for how many cycles of this chamber not been altered, it read less than it did in 2022. This child would be alive today. So in my mind, that is an individual that runs a business entity with the goal of making money and throwing safety and caution to the wind. I have heard that she had wiped her laptop, that I also heard from the detective when they were trying to obtain a cell phone. I don't know if that was in a parking lot or where it was. She actually ran from the investigators. I also heard from the detective that there were statements. I really am hastened to get too deep into this because if there's anyone in the courtroom, I don't want to upset them. But I will state that I believe there was inappropriate use of still photographs taken from the CCTV of this incident, and comments made regarding that. There's also information regarding a previous Attorney General investigation that your office handled that involved an individual lying essentially about accreditation to work in the facility.
Judge, if I may, that wasn't raised here. I haven't had a chance to respond.
Well, he can raise it if you'd like to state it.
Well, Judge, I think, and actually the prior investigation that I was referring to isn't even that investigation. It's another investigation involving healthcare fraud allegations. So that is the people's overarching concern, is it is very clear that this defendant, and thank you for reminding me, Judge, and Detective Trigger told me that this defendant literally, when it was made clear her phone was to be examined, she grabbed it and ran. So the people's overarching concern is that this defendant has a well-documented history of attempting to impede law enforcement, and her lack of appearance would be, the cherry on the sundae, if you will, of impeding the investigation to the best of her nature.
Well, in order to maintain the integrity of the judicial proceeding, I have to ensure that she's not going to continue a behavior that's alleged, that she will appear in court as directed. But what I can't get beyond is an individual whom the allegation suggests would put a person at risk of harm by simply not adhering to standard safety protocols and tampering with the reading of this particular chamber. The very nature of the hyperbaric chamber is higher levels of oxygen, highly combustible, risky, dangerous. Should really be handled with the utmost care and concern and respect. The history of Ms. Peterson troubles me as it relates to impeding investigations. This case is of great concern for public safety. If this is how this operation is being run, I'm so relieved that this hasn't happened before. I'm horrified for the family, and I'm not going to call it tragic because, again, I don't think that's the correct term. I think this was foreseeable. Tragedy implies something that's not. She does have access. I will take the passport. We will take that prior to any posting of bond. That will have to be submitted to the police department for safekeeping. She does have essentially a cash business. She has the ability to She has the means to leave. She has the ability to circumvent this investigation based on her history, the best predictor of future behaviors past. But what I'm going to do at this point in time is set her bond in the amount of $2 million with the following conditions. She'll be under the supervision of pretrial services. She will have no contact with Alita M, Gary Markin, or Jeffrey Mosteller. She will not return to the Oxford Center, neither virtually or in person, the Troy location or the Brighton location. She shall submit her passport prior to release. She will be affixed with a GPS tether, steel cuff prior to release, with home confinement and restricted leave. No contact with any current or past employee, officer, service provider, or maintenance entity which has had any contact with the hyperbaric chamber in question. Do not leave the state of Michigan without permission of the court. Personally appear for all court proceedings. No new criminal offenses or activity. And immediately notify the court in writing of any address, phone number, or email changes. No corporation or business entity of which defendant is, was, an owner, officer, or director of care, past or present, shall operate a hyperbaric chamber in the state of Michigan. The Oxford Centers shall cease all operations related to hyperbaric chambers.
Your Honor, if I may?
One moment.
Yes, ma'am.
Furthermore, she is not to possess any firearms or weapons, and they shall be turned into the arresting agency and provide proof to the court at 524 bond compliance at OCOG.com within 24 hours. Mr. Gleason.
Your Honor, the court consider a 10% revision. That's a very substantial bond.
The bond that I set is actually lower than I anticipated.
You're the judge.
Thank you. Are you going to take her out? Okay. Calling 25-000875 People of the State of Michigan versus Gary Markin. Courtesy for the record. We'll just wait for that. Thank you.
Thank you, and good afternoon again, Your Honor. Assistant Attorney General Chris Kessel for the people.
Thank you.
And good afternoon, Your Honor. It's good to see you. Raymond Kassar on behalf of Gary Markin.
All right, how are we proceeding with the arraignment?
Your Honor, at this time, my client would waive the formal reading. My client would also stand mute to the charges.
All right, thank you. Indicating a waiver of the formal reading, a plea of mute to the charges will enter on your behalf, sir. You do have the right to be represented by an attorney. You sought out and hired your attorney of record, had you been unable to do so, and upon request, you would have been considered for the appointment of an attorney. Furthermore, as you are charged with felony offenses, you do have the right to a probable cause conference within 14 days. You also have the right to a preliminary examination within 21 days. That is a hearing in which the prosecutor bears the burden of proof to establish by probable cause that a crime was committed and probable cause that you committed it. The examination date is March 19th, 2025 at 2:30.
Exam, Your Honor, or probable cause?
Excuse me, probable cause.
Yes, Your Honor.
Thank you. And the examination date is March 26th, 2025. And sir, I should also indicate to you that you do have the right to remain silent. Anything you say orally and writing can be used against you in court. So I have indicated a waiver of the plea, enter pleas of mute to the charges. Next issue is bond. Ms. Rogers?
Your Honor, Brenda Rogers, pretrial services. I did interview the defendant. I was not able to verify his information. He did provide his wife, but did not have a phone number for her. He reports he's 65 years old, born in Michigan. He's been married for 41 years. He has 3 adult children, currently living with his wife in Spring Arbor. He reports living in Jackson County for the past 6 years. Working full-time at the Oxford Center as a director of facilities at the Brighton location. He states he's been there for 16 years. Regards to alcohol, marijuana, or any drug use, he denies all use. Reports he's in good physical and mental health. The defendant has no prior criminal history on record. However, there is great concerns regarding the allegations and the possibility of penalties if convicted. The defendant does have gainful employment of 16 years. He has stable residence. He has no prior criminal history, no outstanding warrants, no pending matters, and no history of failing to appear. Therefore, release on personal recognizance is being recommended. Pretrial services does have concerns for the public safety related to the continued operations of the Oxford Center, and for those reasons, the following conditions are being recommended. Not to return to the Oxford Center virtually or in person, have no contact with the co-defendants in this matter, must surrender passport to the court within 24 hours of release, be supervised by pretrial services supervision, no possession of a firearm or dangerous weapon, and no contact with the family of the listed victim.
Would you please name adding that as a condition of bond to your client as well, no contact with the family of the listed victim?
Yes, Your Honor.
All right, thank you. Counsel?
Thank you, Judge. Again, I think we don't need to go over some of the more, some of the specifics regarding the seriousness of the case. I will say that people outside of the general concern about flight in a case this serious, we don't share the same concern about flight with respect to this defendant as we did with Ms. Peterson, for the reason that we stated on the court, to the court. But again, we are greatly concerned, as we talked about with respect to Ms. Peterson, that this defendant was personally involved in altering these machines in a way that made them seem like they were safer than they were, made them seem that way to the manufacturer, made them seem that way to the patients. And again, in this case, it was this one specific machine that multiple witnesses have identified that this defendant was working on, rolling back those numbers, in essence. I hesitate to use this phrase, Judge, but I don't know one that's more applicable. He was literally making this a ticking time bomb. That's what his actions were doing. So the people are very concerned about that as it relates to bond. Otherwise, I think the rest of the factors have been addressed with respect to Ms. Peterson, so I don't have anything additional. Actually, other than to say, and I suspect the court is leaning this way, that this defendant, as part of his bond conditions, should have nothing to do with the Oxford Center or any other hyperbaric oxygen treatment facilities or treatments or anything of that nature.
Thank you. Counsel?
Thank you, Your Honor. Your Honor, first and foremost, we do recognize the seriousness of the charges. At Attorney General Nessel's press conference a couple hours ago, she indicated these are merely charges and the accused is presumed innocent. And I want to keep that in the court's mind, that he's presumed innocent. I will tell you that Mr. Markin has not been to the Oxford Troy facility in over 3 years. I don't know where the information is coming from that he is rolling back any of these things, but I can tell you that we're confident he hasn't been to that facility because he worked at the Brighton facility. However, Your Honor, with respect to protection of the public, there's no concern that he is going to do anything at this point in time to endanger the public or do anything that would cause the court concern to the public. He didn't operate these machines, Your Honor. He was a facilities manager, and I'm sure that's going to come out at the time of the preliminary exam. Your Honor, with respect to previous criminal history, none. 65 years old, married 41 years. His entire family is in this courtroom. They support him. He was on salary. He was not making a huge amount of money at this corporation. He does not have ties to any other countries. He doesn't have any major assets to give to the court. But I will tell you the most important thing that the court should know and take into consideration is that we were offered an opportunity to sit down with the authorities, and we agreed to sit down with the authorities with the understanding that we could bring this man in when the charges came due. He sat down with the authorities, explained his role, explained his involvement in this, gave his passcode to his phone, and we were under the impression that we would be able to bring him in today, walking him in as opposed to him in handcuffs. Your Honor, I think that goes a long way towards your recommendation for bond. If this guy's willing to sit down with the authorities and give his side of the story freely and voluntarily, then you have to take that into consideration. And I know Sergeant Flood's in the courtroom, and he would be nodding his head right now and saying, yes, that's correct. He did sit down. He did agree. Others may or may not have done that, but we did, Your Honor. Your Honor, he's cooperated again with the police. He is battling skin cancer. He is scheduled for surgery April 1st. I think the court should take that into consideration. I think that makes sense. He's led a full life of law-abiding. Now, I don't know what proofs they're going to be able to show with respect to rolling back these tickers or these things, but I think that they've got a heavy burden to show that he knowingly did this and that he knowingly knew there was a risk of harm, of death in a case like this. Your Honor, with respect to probability of appearance, he lives here in Michigan. He's lived in Michigan all his life. There is no reason for him to leave. Again, I bring up the fact that why would he sit down with the authorities and discuss the case with them when they were in need of information that he provided? Your Honor, I think the recommendation for a high bond wouldn't, if there's a recommendation for a high bond, I would disagree with it. I think pretrial service is correct. A personal bond makes sense. You can achieve all these goals by giving him a personal bond with conditions like a GPS tether. If you want to keep track of him, that's fine. A GPS tether makes sense. There was no reason that he would flee. There's no reason that he would leave the jurisdiction. I'm asking the court to allow us to really represent him instead of representing him behind bars. I'm assuming there's going to be volumes of discovery in this case, Judge. And as you know, dealing with the jail, going back there with computers and videos that we're going to have to look at is going to make this case 10 times harder. I'm asking you to consider a personal bond. I'm asking you to consider, if you are not inclined to do that, some sort of a 10% bond that is reasonable in this case. And again, I have to make a big deal about the fact that when he was asked by the police, will you sit down and cooperate with us, he said yes, and he did. So, Your Honor, I would ask the court to take that into consideration, take into consideration the health, the issues that we've got to deal with, that he's got surgery scheduled for April 1st, and impose a reasonable bond with conditions as you see fit, Your Honor. Thank you.
Mr. Markin, have you stated your opinion for the record as previously stated?
Gary Markin.
Thank you. Sergeant, would you like to respond to anything that counsel brought up?
Oh,
Sergeant Flood is.
Oh, Sergeant Flood? Yes. Would you like to reply to any of that?
What counsel says.
Okay, thank you. All right, so again, purpose of bond is twofold. It's to ensure your appearance in court as well as protection of the public. This case, by the very nature of the allegation, the hyperbaric chamber with high saturations of oxygen is essentially a ticking time bomb. If that unit is tampered with, it becomes Russian roulette for whoever gets into that chamber. This was a 5-year-old boy. His life is gone. His mother essentially did what all parents would say, I would walk through fire for you. My understanding is she put her arms into fire to try to save her son. I cannot risk that happening to any other human being on the face of the planet Earth. That is such a torturous, horrific, heinous image. I have to ensure that you never have the ability to come near, or I'm not saying never, I'm saying while you're on my bond, not come near any sort of facility that participates in the treatment using hyperbaric chambers. I also, going back to my understanding of his involvement with Ms. Peterson, is that they basically worked hand in glove. They shared an office at the Brighton location. If he were to be the person that we're doing her bidding, turning these things back, obviously that's a very dangerous person in my purview. The charges are substantial, they're severe. We're dealing with a murder 2 charge, in addition to the involuntary. I need to ensure his presence in court. I need to ensure the protection of the public, and I am setting bond in that regard to do so. I am setting bond at $250,000, cash surety with no 10%, pretrial services supervision, no possessing any firearms or weapons, period, to the arresting agency and provide proof to the court at 54 bond compliance bill.com within 24 hours. No contact with Tamala Peterson, Jeffrey Mosteller, or Alita Moffett. Do not return to the Oxford Centers in Brighton or Troy, virtually or in person. There will be a GPS tether prior to release, passport turned in prior to the release to the police department, with home confinement, restricted leave, attorney, medical, in court. In addition to verified employment, I don't know what that will entail. Shall not seek employment with any entity that provides hyperbaric chamber treatments. Do not leave the state of Michigan without permission of the court. Personally appear for all court proceedings. No new criminal offenses or activity. Immediately notify the court in writing of any address, phone number, or email changes. No contact with any current or past employee, director, officer, service provider, or maintenance entity which has had contact with the hyperbaric chambers at the Oxford Center. Any questions? All right, you can see this, sir.
Thank you, Your Honor.
Line 25-000878FY, people of the state of Michigan versus Jeffrey Allen Mosteller. Peterson, for the record, please.
Thank you. Good afternoon again, Your Honor. Assistant Attorney General Chris Kessel for the people.
Michael Dick on behalf of Mr. Mosteller.
Mr. Mosteller, would you state your full name for the record?
Jeffrey Allen Mosteller.
Thank you. How are we proceeding with arraignment?
At this time, my client would like to waive formal reading and stand mute.
Mr. Mosteller, I'm indicating a waiver of the formal reading of the charges. Please, if not guilty, vote enter on your behalf. You do have the right to a probable cause conference within 14 days. Yours is scheduled for March 19, 2025 at 2:30 p.m. before Judge McGinnis. For the PCC, you also have the right to a preliminary examination within 21 days as a hearing with the prosecutor as to establish by probable cause that a crime is committed and probable cause that you committed it. And that is set for March 26, 2025 at 9 a.m. You also have the right to remain silent. Anything you say orally or in writing can be used against you. You also have the right to be represented by an attorney. Is he requesting appointment of counsel?
I believe he indicated that he believes he might have retained, but I'm not certain at this point. We did fill out a request for attorney form, Your Honor.
All right, sir, so you've got a few options. You can hire your own attorney, which may take some time. I don't know what your financial situation is. Or you can petition the court for the appointment of an attorney, and that would be appointed by the MIDC, and they would determine whether or not you're eligible. Or, of course, third and bad option is to represent yourself.
Well, then I'll go for the court appointment.
Okay. So at this point in time, I will review your petition for the appointed counsel. If you are able to secure retained counsel, we ask that you do contact the court so that we can call off an appointed attorney. All right, sir?
Yes, ma'am.
Your Honor, not to interrupt your review, but this does include employment at the Oxford Brighton location, so any income, if that were going to be.
Okay. so based on the information that's been provided, taking out any income from the Oxford Center, and you find that you qualify for the appointment of an attorney, so one will be, I will send this up to the appointing authority to have an attorney to represent you. Does your phone number end 6719? All right, thank you. The next issue is bond, purpose of which is to ensure your presence in court as well as protection of the public. Ms. Rogers?
Ms. Jenner, Brenda Rogers, pretrial services. I did interview the defendant. The report was completed by investigator Heather Golan. She was able to verify the defendant's personal information with his girlfriend Pamela Vera. The defendant is 64 years old, born in Georgia. He is divorced since 2016. He has no children. Reports living in Clinton Township with his life partner Pamela since 2019. He does report full-time employment at the Oxford Center in Brighton, Michigan as a safety director and educator. He states he's been there since July of 2019. He does report he's obtained an associate's degree in underwater technology. He denies any use of alcohol, marijuana, or illegal drugs. No history of substance abuse was reported. He states he's in good physical and mental health. He reports that he was arrested on this offense during a traffic stop in Clinton Township on yesterday's date. Defendant has no prior criminal history on record, no outstanding warrants or holds or history of failing to appear, no pending matters. While there is great concern regarding the allegations and possible penalties if convicted, there is no reason to suggest that he's a threat to the community at large or a flight risk, given his stable residence and employment. Also, given the concerns for public safety, pretrial services have concerns regarding the continued operations at the Oxford Center. For that reason, we are recommending the defendant not return to the Oxford Center either virtually or in person. He be released on personal recognizance, supervised by pretrial services supervision, no possession of a firearm or dangerous weapon, no contact with the listed co-defendants or the family of the listed victim, not to return to any Oxford Center, must surrender his passport to the court within 24 hours of release.
Oh, thank you. Your Honor, again, as with respect to Mr. Markin, this defendant, we don't need to, sorry, I'm getting echo here. We don't need to repeat, the seriousness of the offense. Again, there is not any specific concern with this defendant as it relates to flight outside of the serious nature and potential penalties in this case. This defendant was the, for lack of a better phrase, safety officer at the Oxford Center, which is something, considering the way that this facility was being operated. As the court is aware, multiple safeguards were being disregarded knowingly. The investigation showed that this defendant was conducting his own experiments to try and prove the safety as it relates to this particular chamber. Judge, obviously these were his own experiments, none of which were actually recognized by any sort of scientific body. They were not peer reviewed. And the people's position is they were just designed to hide the actual safeguards that were being disregarded. That these experiments were meant to show the under-employees that what they were doing was safe, because look at these experiments that he conducted. So that, again, is to Mr. Markin, that is the people's concern, that this defendant had no contact with and had nothing to do with any sort of hyperbaric oxygen treatment, or really any other treatment involving oxygen as well. I would ask the court to incorporate those into its bond conditions.
All right, thank you.
Your Honor, we are asking for a reasonable bond. My client has no prior criminal charges or convictions, no prior failure to appear. I have no doubt that if he were made aware of the charges, he would have appeared in court today on his own volition rather than being pulled over in a traffic stop in which there were no new pending charges or tickets issued. I believe he was just stopped like many of the other defendants here in order to be picked up at the same time. A lot of the safety concerns I believe can be adequately addressed through the terms of his bond. Though through any specific ones that were just mentioned, I don't feel confident directly speaking to those, as I am not going to be his counsel moving forward, so I don't want to speak to any specific allegations. But other than his clean record, we would ask for a reasonable bond in this place, Your Honor.
All right, once again, purpose of bond, twofold: ensure your presence in court, protection of the public. As a safety director, the allegations suggest that you were the failed stop, taking direction purportedly from someone above you as how to run this facility. And what the prosecutors just indicated to me is frightening, that safeguards were not utilized, experiments were done to show employees, lead them down a wrong path, that things were safe when obviously they were not. Not tragically, not gonna use that word. This could have been prevented if proper protocols were followed. I can't get over that form of judgment was utilized. And if that's the form of judgment that you're utilizing in your life, I have some concerns about you and your ability to participate in the criminal process going forward. I don't know what other judgment calls you would make in terms of would you plead, would you not come back to court. This case is too serious. It must be brought before the court system. For those reasons, and incorporating by reference other statements previously made on the record, I am setting your bond at $250,000, cash surety, no 10%, pretrial services supervision, no possessing any firearms, returning to the arresting agency and provide proof to the court at 52-4 bond compliance, no.com within 24 hours, no contact with Pamela Peterson, Gary Markin, Alita M, no contact with the family of the listed victim, do not return to the Oxford centers, either Troy or Brighton, virtually or in person, GPS tether prior to release, steel cuff, restricted leave, home confinement, attorney, medical, and court, and verified employment. You shall not seek employment with any entity that provides hyperbaric chamber treatments or the use of oxygen. Passport to be turned in prior to release to the police department. Do not leave the state of Michigan without permission of the court. Personally appear for all court proceedings. No new criminal offenses or activity, and immediately notify the court in writing of any address, phone number, and/or email changes. And I haven't confirmed any of these defendants' addresses on the record for a purpose, and that's because everything's being recorded, and I'm not trying to turn everyone's address to the public. But we will need to confirm that prior to everyone departing today. No contact with any current or past employee, director, officer, or service provider or maintenance entity which has had any contact with hyperbaric chambers at the Oxford Center. Any questions, sir, regarding your bond or any of its conditions?
Okay.
Have a seat, sir.
Thank you, Your Honor.
Or actually, you can go with the officer. Calling case number 25-000877 SY, people of the state of Michigan versus Alita Harward Moffett.
Thank you one more time, Your Honor. Assistant Attorney General Chris Kessel for the people.
Thank you.
Good afternoon. Ellen Michaels on behalf of Alita Moffett. My P number is 67943.
Thank you. Would you please state your full name for the record? And counsel, just to inform you, I was handed a stack of what appeared to be letters in support. I did not read them because I did not believe they were submitted to you at that time.
They were, Judge.
Okay.
I spoke with counsel yesterday. She let me know they were coming. I
Okay.
did have a chance to have a look.
All right, thank you. So I can review those, or you can summarize those, whichever is your preference. But in the first instance, we are here for an arraignment. So how are we proceeding?
Well, for purposes of the arraignment, we'll waive formal reading and I'll stand my client mute.
So I'm indicating a waiver of the formal reading. A plea of mute enters on your behalf to the charges.
Would Your Honor be willing to step away from the bench for 5-10 minutes to review those letters? We would prefer that.
My concern was just that. I wanted to make sure that they were provided. I see that.
Yes.
I didn't want to assume that. So
I understand. I should have let the clerk know. I did actually.
Okay.
Either way, I sent the letters to the Attorney General last night. with a follow-up this morning on some additional letters, and all of those were hard copies given to the staff of the court.
Okay, so let's get through to the arraignment stage, to the bond stage, and then I'll take a brief break, okay?
Thank you.
All right, so this is a 2-count complaint. How are we proceeding with the actual arraignment?
We waive formal reading and stand my client mute.
All right, so I've indicated a waiver of the formal reading, a plea of mute to the charges is entered on your client's behalf. Ma'am, you do have the right to have a probable cause conference within 14 days. That is a hearing in which the prosecutor, not that one, probable cause conference within 14 days. That's going to be scheduled for March 19, 2025, Judge McGinnis at 2:30. You also have the right to a preliminary examination within 21 days. That is a hearing in which the prosecutor has to establish by probable cause that a crime was committed and probable cause that you committed it. So that will be March 26, 2025 at 9 a.m. You do also have the right to remain silent. Anything you say orally or in writing can be used against you in court. You hired an attorney, so you retain counsel. Had you been unable to do so and upon request, you would have been considered for appointed counsel and had appointed counsel if you were eligible. Any questions so far, ma'am? All right. So I am going to take the letters into chambers, and I will take about a 15-minute break, and then we'll reconvene and address them.
Thank you so much.
Thank you, Judge. Or Your Honor.